Hello and welcome to today's webinar, The Main Legal Issues Surrounding the Nile Controversy and Future Prospects. My name is Sarah Bushin and I am the president of the Ethiopian Legal Professionals Association of North America, ELPANA, your host today. First and foremost, I would like to start by expressing my deep appreciation to Ato Imeru Tamrat for accepting our invitation to be our guest speaker. Thank you to all of our participants as well for joining us on this Zoom webinar to hear from our subject matter expert on one of the critical issues of significant importance for our home country. This will be the first of quarterly webinars ELPANA plans to organize on Ethiopian laws and legal issues that are of critical importance for the nation, mainly for the consumption of legal professionals in the diaspora. It is our hope that this humble initiative will help to serve to inform, engage, and propel into action, as the case may be, again, the legal professional, to participate in the current dialogue and conversation that is underway in the country on the path towards transformation and inclusiveness, while the rights of all individuals and peoples are respected. Our moderator for the webinar is Ato Hailu. Zacharias is a graduate of Addis Ababa University, Faculty of Law, and also Yale Law School here in the US. Among his many accomplishments, Zacharias has served as administrative court judge here in Minnesota for several years and is currently director of Equal Opportunity and Access Division at Minnesota Department of Human Services. Without further ado, I now pass on the program to Zacharias to guide us into the next steps. Thank you very much.
Thank you very much, Sarah. Good morning, everybody. Good morning in the US. Good morning, good afternoon in Europe, and good evening in Ethiopia. My name is Zacharias Hailu, and I'm here today to introduce Ato Imeru Tamrat. But before the introduction, let me do some housekeeping. We estimate that the total webinar time to be 1 hour and 30 minutes. The webinar will have two sessions. The first session of 45 minutes will be presentation by the subject matter expert, and the second 45 minutes will be Q&A session. Questions should be sent via Zoom chat option during the first session to me. Your voice is muted, so the question could be sent only through chat. Additional question could be taken as time allows during the Q&A sessions. The webinar will be recorded and made available on demand after the event once set up on our website. If you have any question regarding this, please send us your questions through the chat. And after that, let me go to the introduction. I've known Imeru since high school days when we were teenagers at General Wingate School. We parted our ways and then meandered, and then I saw him back at law school. He was 1 year my senior at Wingate, and also at the law school, he was my senior by 1 year. Imeru has an LLB degree from Faculty of Law at Addis Ababa University in 1987. He was a Chancellor's Medal recipient at the time. He continued his education and earned LLM in International Environmental Law and Natural Resources from the School of Oriental and African Studies at the University of London in 1992, from where he graduated with merit. From the time he graduated from the law school in 1987, Imeru was immersed in water law and still swimming in it, no pun intended. Imeru has vast, extensive experience in the water sector and has represented Ethiopia in several regional and international forums of significant importance for the nation. Some of his notable positions and experience include Head of Transboundary Water Resource Department of Ethiopia, and he was also part of the Ethiopian delegation during the negotiation which led to the 1997 UN Convention on the Law of the Non-Navigational Uses of International Water Courses. He was a member of the panel of experts in the initial stage of negotiation of the Nile Basin Cooperative Framework Agreement and member of the advisory group in later negotiations. And Imeru is a member of the support team in the current trilateral negotiation between Ethiopia, Sudan, and Egypt on the Grand Ethiopian Renaissance Dam. In addition to his notable work experience, Imeru has taught international environmental law and international water law postgraduate level programs at the Addis Ababa University Faculty of Law for a period of 5 years. Imeru was also a member of the Advisory Committee of the United Nations Human Rights Council from 2012 to 2018 and chair rapporteur of the Working Group on the Communications, which is complaints procedure of the UN Human Rights Council from 2014 to 2018. The title of his presentation today is The Main Legal Issues Surrounding the Nile Controversy and Future Prospects. And the question of the Nile is one of the most burning issues Ethiopia is facing currently. And it's very hard to find anyone more qualified who can speak on this topic. So we are lucky to have Imeru today amongst us. And without much ado, I invite Imeru to start his presentation. Go ahead, Imeru, take it.
Thank you very much. I'm having problem of bringing the presentation on the slide, but can you see me?
Yes, we can see you clearly. Go ahead.
Okay, let me go ahead. I thank you very much. Good evening, good morning, good afternoon, ladies and gentlemen. I'd like first to thank ELPANA for inviting me to this, as Sarah mentioned, issue of national importance. And in particular, Sarah, who initiated this process and pushed me to make this presentation. I'm glad to make it. And I also thank the moderator for informing you of my experience. I'm not sure I'm a highly qualified person, but Zacharias has given me a good introduction. And I'm also glad, and I understand that although we haven't met physically, I think I know most of the participants, so it's good to reconnect virtually. So without much ado, as I'll continue with the presentation. Zacharias has mentioned the topic. It's the main legal issues surrounding the Nile controversy and future prospects. Legal issues, as looking at it, well, legal and political issues might be better because you cannot separate the legal with the political issues surrounding the Nile also. So on the next slide, this is the outline. I'll start with why international water law? Why do you need international water law? And then I'll continue to discuss briefly contending concepts and theories that existed during the development of international law. And then the codification, we can say, of international law. Basically, currently, the one in place at the international level is the 1997 UN Convention on the Law of Non-Navigational Uses of International Rivers. And then I'll proceed briefly to discuss also the context of the Nile and the colonial and the post-colonial agreements, including their status. Then I'll continue to discuss the cooperative initiatives that were in the Nile and now in place. Then I'll come to the main discussion, which is the Grand Ethiopian Renaissance Dam and the major negotiation milestones to date. I'll proceed, with the Washington process and the post-Washington developments. developments we see developments day by day. So I'll also talk about that, and then finish with what would be the future prospects and scenarios. I'll start with this quote. It says, "Whiskey is for drinking, and water is for fighting over." I think most of you will agree with me that whiskey is for drinking. We've had experience in that when we were young guys. But the second is a bit controversial, which is water is for fighting over. This is a quote I took from a book from Mark Twain. In the Midwest, in the 19th century, water was scarce, and that's why he said water is for fighting over. But would fighting over water be worthwhile is a question that I want you to mull over when I make the presentations, and then we can discuss it at the end. Why international law? Why international water law? As you know, water is a fugitive resource. It never stops. It starts from somewhere and moves and crosses political boundaries. It ignores political boundaries. It is blind to political boundaries. So hydrologically speaking—
Hi, Imeru, can you share your screen, please?
Oh, so you don't see that?
Yes, we are not seeing your screen.
So I better, that's the problem that I was asking. I wanted to share the screen. Let's see. I thought you— do you see it now?
Yes.
Sorry for this. I thought you were looking at the screen. But let me continue now. If you're seeing it now, does everybody see it now? Okay, let me continue. So as I've said, water does not respect political boundaries. So, but unfortunately, political boundaries exist. And therefore, international law is needed to determine the relationship, the rights and obligations of states in this respect, because sovereignty is also involved in that. It gives rise to externality. It is called as a common pool resource. So if upstream countries, for instance, consume the water resources for irrigation, then it reduces the amount of water resources going downstream. And if downstream countries also build a dam, for instance, and there is flood water going back to upstream countries, then there is externality. So because of externalities, there is an interdependence among water users in an international resource. But this is also true at the national level. Many of the theories that have developed under international law stemmed from, in fact, from interstate disputes in the United States. There might be potential disputes even in Ethiopia between among states. So this is an issue not only of an international nature, but also at the national level. But under international, at the international level, it affects relationship among states, and to determine their rights and duties when using the water courses is important. And that is why international law has been important. There were several contending principles and concepts that were propounded by states in the past. One of it is the theory called the absolute territorial sovereignty. This was first propounded by United States in its disputes between in the dispute between Mexico and the United States on the Rio Grande River in 1897. And it's otherwise known as the Harman Doctrine, because it's the Attorney General of the US said at the time that there is no international obligation for a state to limit its use, or irrespective of the impact that it can have on downstream states. Mexico as the downstream country, and Mexico raised the issue that, that the natural flow or the sufficient flow should come from the United States. And that's why it's called absolute territorial sovereignty. The Harman Doctrine said there's no international law that limits states from using their resources irrespective of the impact that it entails on other states. However, this theory has eventually been replaced by what we call the limited territorial sovereignty, which I'll come back later. But one of the reasons why this theory was eventually discarded was that the United States itself was a downstream country to many of the rivers that come from Canada, like the Columbia River, for instance. So in that case, United States was a downstream country. So it eventually said that it went to the accepting the limited territorial sovereignty principle. The absolute territorial integrity is a principle that is claimed usually by downstream countries, saying that the natural flow of a river shouldn't be touched at all, and it should flow downstream. This principle is usually propounded by Egypt, as you shall see later on, and by some downstream countries, which claim that nothing should, the upstream countries shouldn't affect the flow going downstream. But later on, the most accepted principle has become the limited territorial sovereignty, which says that the sovereign rights of states in using their water resources should satisfy, or should be shared by all the countries that use the resources. And it is from this principle that the principle of equitable utilization, which is the current principle of international law, the governing principle of international water law, has emerged. The other one is the community of interests. This propounds that let's forget political boundaries, and all countries that share the water resources should use their water resources together. But this hasn't been accepted. It's an ideal theory, but this is not an accepted principle at this moment in time because of the existence of sovereignty. So it's the limited territorial sovereignty that has gained acceptance and later on developed to international water law. I wouldn't go about talking about whether international water law is it's a branch of public international law. I think it basically applies to states. It determines the relationship between states, so it's part of public international law. What I wouldn't discuss many of the case laws that exist in this. It will take time. But the major codification of international water law was developed by a group of international jurists called the International Law Association, which is called the 1966 Helsinki Rules. This was the first time that a series of provisions were incorporated that reflected basically the customary international law practice of states in this regard. What I'd like to note here is that in the Helsinki Rules, the substantive principle that was incorporated was only the principle of equitable utilization. As you might hear several times now, there are two major substantive principles, which we'll discuss later. The principle of equitable utilization and the principle not to cause significant harm. But this didn't exist when the Helsinki rules was developed. The second principle, not to cause significant harm. The operating principle under the Helsinki rules was equitable utilization. What they basically said was that if a state utilizes its water water in an equitable manner, there could be no question of entailing harm on other states, which is the logical, which should have been the logical conclusion. But later on, when the 1997 Convention on the Law of Non-Navigational Uses of International Courses, the negotiations started in 1972. The development of the provisions regarding international water courses changed in terms of including as one of the substantive provisions the principle of not to cause significant harm. The 1997 convention took around, it started in 1972 and then took around 25 years in order to be concluded and adopted. You can see that it was quite a difficult negotiation. Many states did not agree to some of the provisions in the agreement. And that's why there was this long negotiation. The major contentious principles was the relationship between the principle of equitable utilization and the no significant harm. Many countries, including Ethiopia, argued that the principle of equitable utilization should be the governing principle in using international water courses. And it's only the no significant harm can only be triggered if countries or states pass their right to equitably utilize the water resources. But other countries said no. Egypt said that, in fact, that the no significant harm should take precedence. There was a lot of argument here. So finally, there was a balance made between these two provisions, which I'll come later on. The convention is a framework convention, meaning that it only lays down general provisions on which states can develop their own agreements in their respective basins. In the specific agreements would only be agreed by the water course states in the future. So it's a framework convention which lays down general principles. It was adopted by 103 countries at the time of adoption in 1997. There were 3 against: China, Burundi, China, and Turkey. As you can imagine, China and Turkey are upstream countries, mostly upstream countries, and therefore they did not accept especially because of the unclarity between the relationship of equitable utilization and the no significant harm. There were 27 abstentions, and among these, all of the Nile riparian countries, except Burundi, which surprisingly adopted the convention, although it's not a major stakeholder in the Nile Basin. But all other Nile countries abstained from adopting the convention for different reasons. Ethiopia, for instance, was not was not happy. The one specific provision that Ethiopia did not accept was the notification procedures, which is it basically obliged the states to notify planned projects. And it has detailed provisions on that, which basically tends to prevent upstream countries from using their resources. It accepted the principle, but it said that since the convention is a framework convention, there is no need for such detailed provisions. Regarding the relationship between equitable utilization and no significant harm, the final provisions were basically leaning to accepting the principle of equitable utilization. So Ethiopia did not have much problem with that. Egypt had a problem because it wanted the principle of the obligation not to cause significant harm be the preponderant or governing principle of international law. So it also abstained, it didn't object. The required ratification was 35 countries. As you can see, it came into force in 2014, so it took about 17 years even to get a ratification of 35 countries. And therefore, you can see that states are still reluctant. It's around 45 countries that have already ratified this convention. But you can see that states have reservations on certain of the provisions of the convention, but basically it incorporates the major principles of international law. As I said, these are the major substantive or provisional principles. I'm afraid I should not take much time on this. The major substantive principles are the principle of equitable and reasonable utilization, which are included in Article 5 and 6, and the duty not to cause harm. These were the major contentious principles, especially the relationship between equitable and reasonable utilization and the duty not to cause significant harm. The duty not to cause significant harm does not have is not provided in absolute terms. It only has an obligation of conduct, but if harm is nevertheless caused, it always directs it to the principles of equitable utilization. There are several factors that have been detailed in the convention to determine the principle of equitable utilization. And if significant harm arises, it says that it should be discussed by the basin states based on the factors that are stated in Article 6, and basically leads us to the principle of equitable utilization. The provisional provisions that were contentious were, as I've said, the notification of planned measures. There are detailed provisions on that. It's not only the principle that have been provided here. So many countries had problems on that because it states that once a country notifies, it should wait for 6 months for the other country to study the planned measure. It takes around 6 months or a year to do that. So many countries were not happy about that, including Ethiopia. And there are dispute resolution provisions, which are similar to the major dispute resolution provisions in international agreements, and I'll not go into details in that. The context of the Nile, very quickly. I don't think I'd go at length to describe the hydrology of the Nile. Maybe that would not be of much interest to you. We can discuss it later on if it's relevant. But basically, it's the colonial agreements and the post-colonial agreements that we should see. The 1929 Nile Waters Agreement was basically initiated by Great Britain, which was also a colonial power in most of the Equatorial Lakes countries or the White Nile countries like Kenya and Uganda. And because of its interest in Egypt, it basically, the agreement basically was between Great Britain and the upstream countries. You might say Great Britain with Great Britain. And on behalf of the upstream states, it basically says that without consultation and agreement by Egypt, that the upstream countries cannot use the water resources. This has been, in the end, rejected by all of the upstream countries after they gained independence. They said that it doesn't represent their interest, and the Nyerere doctrine, the famous Nyerere doctrine, is one of the doctrine that is cited in support of that. Ethiopia was not a party to the 1929 agreement, so it doesn't affect Ethiopia in any way. The post-colonial agreement was made between Sudan and Egypt. It says for the full utilization of the Nile waters. And Egypt and Sudan, as you may know, have divided or shared the Nile waters among themselves. Basically, Egypt has a share of 59.5 billion cubic meters, while Sudan has 18.5, based on the estimated annual flow of the Nile, which is 84 billion cubic meters. And there is 10 billion cubic meters that is left because of the evaporation that goes out of the Aswan Dam. In that agreement, there's also a provision, Article 5, which says that in the event that other countries demand a share in the Nile waters, then Sudan and Egypt will take a common position and to decide on whether the other countries have a right to use the water resources. Basically meaning that creating a veto power in this respect. Then there is the 1902, the agreement between Emperor Menelik and basically the United Kingdom on behalf of the government of Sudan. One thing that you should notice, it's on behalf of Sudan that Great Britain made this agreement. It's not on behalf of Egypt, but surprisingly, Egypt raises this provision many times. Egypt is not a party to this agreement. Basically, it says that it will not construct or allow to be constructed any works along the Blue Nile and the White Nile, so that is the Baro Akobo and Lake Tana, that would arrest the flow of the waters in the Nile. It says would arrest. It doesn't say that that it won't use it. In Amharic, it says Yemidafin Sara al Saram no Mila. So it means not to totally stop the water resources going downstream, but doesn't say that Ethiopia would not use the water resources. There are many arguments that invalidates this treaty. One of it is the change of circumstances, the rebus extantibus, and there are several agreements, but sometimes both Sudan and Egypt raise this as a valid agreement because, as most of you know, this is a boundary agreement. It's surprisingly within the boundary agreement that a separate provision on water has been included. We'll discuss later on this. Did I pass the cooperative initiatives? Okay, now we go to the past cooperative initiatives in the Nile. The first one was the Hydromet project, which was basically collection of data in the Equatorial Lakes Basin. This project was initiated by Egypt and Sudan when the upstream countries gained independence and asked for a share of the Nile waters, they said that unless we know the amount of water that exists in the White Nile, then there can't be any water sharing agreement. It's just to delay the process. I participated in this project starting from 1988. And it was just a defunct project. Egypt and Sudan were basically, Egypt was dominating the project, so it wasn't that much of use. The Undugu, I've not discussed it much. Egypt used it to try to convince the Nile Basin countries, especially the Equatorial Lakes countries, to not continue with demanding water sharing in the Nile. Then came the Teco Nile project. This was because the Hydromet project was defunct. Many of the basin countries said that we need to get funding, and the Teco Nile project started. And it was at this time that Ethiopia said that unless there is a water sharing agreement between the agreement on the principles that should govern the use of the Nile, then we can't continue with cooperation. And this is the precursor of the the CFA, the Cooperative Framework Agreement that was later adopted by most of the upstream countries. So the negotiation on putting a permanent legal and institutional framework in the Nile started in 1997. I was one of the negotiators then, the Nile Basin Initiative was established in 1999. So the negotiations started, or the negotiations on the CFA started before the Nile Basin Initiative was started. The Nile Basin Initiative was established as a transitional framework until the legal and institutional agreement was expected to be agreed upon. Only for 3 years, in fact, when it started, but it's still with us. The CFA negotiations took around 12 years. The main contentious provisions as the 1997 convention was the state of existing agreement. Egypt insisted that existing agreement should be respected, its so-called historical rights should be respected. It also wanted to have detailed provisions on planned measures, notification on planned measures, just like it was provided in the 1997 UN Convention, but later it's only the principle that is provided here. It was agreed also by Egypt. Because of the difficulty of agreeing on the substantive provisions, and because of the insistence of Sudan and Egypt for other countries to accept the existing agreements, finally the upstream countries decided to adopt the CFA, and it was opened for signature. Currently, the required ratification for its coming into force is 6. Currently, 4 countries have ratified it, and 2 countries still remain for it to enter into force. Basically, the CFA is similar to most of the provisions of the Convention on International Water Courses. How many minutes do I have, Zacharias? Zacharias? Can you hear me?
Yes, I can hear you. Can you hear me?
How many minutes do I have?
You can take as much as you want, but 10 more minutes.
Oh, but okay. I've come to the main part of the presentation. I'm not sure that I can finish within 10 minutes, but I'll try to. The Grand Ethiopian Renaissance Dam. What are major negotiation milestones?
Okay.
maybe I discuss the benefits of GERD when we come to the discussions in order not to spend much time. As you know, the Grand Ethiopian Renaissance Dam was commenced in April 2011, and after its commencement, Egypt and Sudan, especially Egypt, sent a public a group here asking for information on the GERD, and the then Prime Minister agreed to form a tripartite to initiate a tripartite talk in good faith. By the way, this is unprecedented in other countries. When this kind of project, which clearly it's a hydropower project, does not entail a significant harm on downstream countries, many countries proceed unilaterally. As you know, Egypt has also proceeded unilaterally downstream without even consulting Ethiopia. So it's basically in good faith that it invited Sudan and Egypt not to reach out an agreement, but to share information and look at the information on the filling of the GERD and what is being done on GERD, so that they would be they would understand that it will not cause any significant harm on downstream states. The tripartite talks started in May 2011, and basically in order to study the impact of the GERD on downstream countries, an international panel of experts was established, which was 10, 2 each from Sudan, Egypt, and Ethiopia, and 4 international experts. And basically it was to conduct a study on the impact of GERD as a whole, both the positive and the negative, the potential impacts that it may have on downstream countries. The study was completed in 2013. Basically, the study was endorsed by the 3 countries once it was completed. Most of the results of the study showed that the GERD did not have any significant impact on downstream countries. The dam safety issue was also studied during this period, and the study said that there is no dam safety issue at this point in time. There wasn't any, but it also said that there are certain issues that need to be studied, and it recommended 2 studies to be conducted. One, a hydrological study, and the other one, an environmental impact study.
Hello, Imeru, can you hear me?
Sorry?
Can you hear me? We talked among ourselves. This is extremely important topic and very informative, so we can give you more time. Don't feel rushed.
Okay, thank you. Yeah, I feel relaxed a bit when you say that. Thank you. The IPOE study findings were basically positive and said that no major impacts would be entailed on downstream countries, but Egypt had major problems. It said that after it's adopted, after the study was adopted, they started to complain about the results of the study. As you may remember, they wanted to reduce the size of the GERD to only store only 14 billion cubic meters. And they said that this is a grand dam that might affect millions of Egyptians without any evidence. And they detracted from the process. There was a war of words. they continue to say that the two studies should not be conducted without first accepting that the dam size should be reduced in order to only fill a certain amount of water, like I said, 14 billion cubic meters instead of the 74 billion cubic meters. There was a delay in conducting the two studies because there were war words, and as you remember, in fact, during the Morsi period, there was also a threat of war, in fact, also televised. So things went from bad to worse for around a year. But eventually, Egypt went to the political process. It went to the political process, talked with the foreign ministers of Egypt, of Ethiopia and Sudan, and eventually they decided to continue with engaging in conducting the two studies. So in August 2014, another tripartite national committee was established to conduct the two studies recommended by the IPOE, which, as I said, were the hydrological impact study and the environmental study. But this also had its own difficulties. In fact, when the terms of reference was being prepared, Egypt suggested that a third party should be involved in the study. It had in mind, as eventually it did, the World Bank and the United States. But at that moment, both Sudan and Ethiopia and Sudan said that this is an issue that should be resolved by the basin countries themselves. And therefore, there is no need for a third party. And eventually, Egypt was forced. In fact, in one of the meeting, it left the meeting because Sudan and Egypt did not accept the third party. But later on, it came back again to the meeting because it was forced to do that. Then there was a lot of controversy, even on the selection of consultants, because Egypt wanted consultants to be selected of its preference, ones that could support its demands. And it took, even the selection of the consultant took around 6 months. Finally, a consultant was endorsed. The draft a report was prepared, but a substantive disagreement was raised during the draft report. Egypt, basically the impasse was because of Egypt insisting that the baseline for studying the impact of the GERD should be the existing water share of Sudan and Egypt, meaning the 1959 agreement, or the existing water use. So what it says is that the existing share of Egypt should not be touched. If any, if the filling of the GERD or operation of the GERD impacts existing use, then that is illegal. And so it's basically was claiming it's what it calls always a historic right of Egypt. And because of this disagreement, it was not possible to continue with preparing the report. So it stopped. But in the middle of the the study, Egypt also insisted to have an agreement, but all countries later on accepted this, and the negotiation was conducted, which was later agreed upon in 2015, the Declaration of Principles on GERD. Most of the provisions, as you may have seen, some of the provisions, especially the substantive provisions in the GERD regarding water use, are a direct copy of the international, the convention on the UN Convention, but there were specific provisions that were included in the agreement. And one of the contentious provisions up to now is Article 5 of the DOP, which basically relates to the filling and operation of the GERD. What it basically says is that the countries would agree on the filling and operation, annual operation of the GERD. However, this would the agreement on this would result only after the studies, the initial studies that were made, that were started and then stopped at the draft report stage, were finalized, because it was intended that the outcome of the draft report would be used as a basis for agreeing the filling and annual operation of the GERD. But the study was designed to be completed in 15 months. It wasn't completed because of disagreement, because of the insistence of Egypt to have the baseline of existing agreement. And it could have stopped at that. But Ethiopia decided to continue the negotiations and to form a national scientific group, independent scientific group. I say independent in quotation because most of them were representatives, were the former negotiators in the tripartite process. This was established in May 15, 2018, and a 9-party meeting was held. By the way, earlier on, it was only the Ministry of Water Resources that was engaged in the negotiations. Of course, together with, in consultation with the Ministry of Foreign Affairs, and representatives from the ministry also used to go there. But later on, Egypt insisted to include the intelligence ministry. And Ethiopia agreed also, and therefore the intelligence ministry was also sat in the meetings. You could ask later why the intelligence was included in this meeting, but it was. The task of the National Scientific Group was to conduct and submit scientific studies to the water affairs ministers of the 3 countries on the filling and annual operation of GERD. Note here that it was expected to conduct and submit scientific studies to the ministers of water affairs. It doesn't say anything about an agreement. The National Scientific Research Group was envisaged to propose alternative recommendations on the filling and operation in GERD, and it was supposed to be decided by the ministers of water affairs of the 3 countries, and later on by the 9-party meeting. This was the objective. Many meetings of the scientific group were made. Some agreements on the initial filling the stage-based filling was agreed upon. But Egypt insisted that unless there is a package agreement that, that includes the demand of Egypt to respect the historic rights of Egypt, then, and also not touching the operation of the Aswan Dam, then there would be no agreement. It insisted on a package agreement, and in the end, this was impossible to continue. Sudan and Egypt insisted on addressing the remaining issues, but because of the insistence of Egypt of a package agreement, including addressing Egypt's demands that the flow going out of the GERD shouldn't affect the total demand of the Aswan Dam, it stopped. But in that period, Egypt again unilaterally submitted another proposal in August 2019. And this was the main contentious issue. There was no provision that Egypt should unilaterally submit another agreement, another proposal, but it submitted a proposal basically saying that any water flowing from the GERD should respect the storage size, size of the Aswan Dam. It shouldn't affect in any way the demand of the Aswan Dam, which actually means accepting the 1959 agreement. It says maintain natural flow. So they were demanding 40 billion cubic meters to come from the GERD, irrespective of the amount of flow that is needed to produce hydropower from the GERD, and also foreclosing any existing and future uses upstream of the GERD. If you accept natural flow, it means that you release the flow to Egypt at any time. You agree to that, and there can't be any upstream flow. And they wanted a guaranteed release, maintaining the high Aswan Dam at 165 meters above sea level, which actually means the demand of the Aswan Dam as before, endorsing the 1959 agreement. And they also said that they should open an office at the GERD site for joint management of the dam, which is actually an infringement of sovereignty. They've done this in Uganda and the Aon Falls Dam, and they wanted to control and regulate and monitor the flow of the GERD sitting at the dam site. And this is a clear infringement of sovereignty. So because of these proposals, there wasn't any leeway to continue with an agreement. So the NISRIJ process was stopped. Egypt was not able to succeed in getting its demand accepted by both Sudan and Egypt, Sudan and Ethiopia. Because of that, it started to escalate the process. Egypt unilaterally approached the US and asked it to get involved in GERD negotiations. And the United States sent an invitation letter to the three countries to attend the meeting on November 6, 2019. Ethiopia and Sudan accepted this in good faith, thinking that there might be only discussions during that phase. But unfortunately, I would say, the meeting of the Ministers of Water Affairs and Water Resources was held in November 6th, and a joint statement was issued, which basically agreed that the US and the World Bank act as third parties, act as observers. It included a third party. I I put observers in quotation because in my view, from the outset, they were not acting as observers. There was no TOR, in fact, terms of reference given to the US and the World Bank for them to act as observers. As many of you know, in international, in UN meetings and so forth, observers can do not interfere with the discussions made among the states. But in this process, the observers did not act as observers, but sometimes as giving views and facilitating the meetings. It was also agreed to continue with the negotiations on that the National Scientific Group started to continue with that and have 4 technical meetings to be held from November to January, and the completion of an agreement by January 15. As you can see, I mean, what took around probably 30, 40 years on Egypt's insistence of accepting their historical rights, or the 1959 agreement was intended to be finished in 3 months, and in almost 1.5 to 2 months. This was a surprising marathon event. How can you imagine that such a contentious issue would be agreed upon by this by the state? Anyway, it happened. As you know, that there was no agreement reached in the 4 technical meetings, basically because Egypt always reverted back to saying that the GERD should release a guaranteed release that would meet Egyptian demands. Even during drought or prolonged drought, the GERD should release to meet the the Aswan Dam requirements, and this was couldn't be accepted. There was an agreement that in the joint statement there was also this provision that says that if an agreement is not reached by January 15, 2020, then it would trigger the dispute resolution mechanism in Article 10 of the DOP. Basically, Article 10 of the DOP provides that if countries do not agree on the interpretation of any of the provisions of the DOP, then they can jointly decide to bring their disputes to mediation, conciliation, or take it to the heads of states. But this this is the provision. If it was not agreed on January 15. Why did the technical round fail? As I said, it's basically Egypt's insistence in meeting, especially regarding the operation of the dam, saying that the operation of the dam, the long-term operation of the dam, should address Egyptian demands at any time to meet their water requirements based on the 1959 agreement. So on January 13 to 15, 2020, the ministerial meeting was held in Washington. In fact, I attended the meeting. And what was expected initially was, because there was no agreement reached by January during the 4 technical meetings, the provision, the joint statement said that it would trigger the dispute resolution mechanism in the DOP. But at that meeting, the USA and the World Bank came very clearly on the side of Egypt. They said that this is a disappointment. Ethiopia should agree on provisions that should meet Egyptian demands. In fact, they started to bring new concepts as prolonged drought years, guarantee Egypt from 38 to 40 billion cubic meters downstream. These were unacceptable provisions, but it happened that Ethiopia was also willing to continue the negotiations, and the negotiations continued with these provisions being pushed by the US. At this point in time, afterwards, after the meeting in January 13 to 15, the countries also agreed to form a legal and technical team to draft an agreement towards the negotiation and finalizing an agreement on the filling and long-term operation of DERT. They met in Sudan, they met in the United States, but finally, because the major differences emerged, Egypt insisted that a provision should be included that that the historical rights should not be accepted, should be accepted by Ethiopia. Most of the technical provisions that were against Ethiopian interest, Egypt demanded, and the United States also supported this. Dam safety was also later on brought by Sudan, but clearly the US emerged not as an observer, but probably a mediator or a party to the negotiations on behalf of Egypt. It clearly came out like that, and therefore in the February 12 to 13 ministerial meeting, Ethiopia rejected the draft that was proposed, mainly by the United States in conjunction with Egypt, and the negotiation broke down. These were unacceptable demands. Post-February, Ethiopia said that it will, public consultations began in Ethiopia, and Ethiopia requested for the planned meeting in February, at the end of February, to be delayed in writing to the United States and Egypt and Sudan, for the meeting to be delayed. Irrespective of that, the US invited both Sudan and Egypt. The ministerial meeting took place. As you know, the US prepared its own agreement and Egypt signed on that. And later on issued a statement saying that unless Ethiopia signs the agreement, it should not start the first stage filling of the dam. And the response was made by Ethiopia that it will proceed to start filling the dam because it's sovereign right by July 2020. In one sense, the statement issued by the US Treasury Department was a blessing in disguise. I mean, I think it showed the public that there is no light at the end of the tunnel. It was darkness at the end of the tunnel. And it clearly showed that the US sided the Egyptian position. And the public discussion emerged countering this. And after that, as you know, there were war words, the Egyptians saying that unless Ethiopia goes back to the negotiating table, then it will go to escalate the issue. As you know, it also wanted to Arabize this water issue. The Arab League, it sought support with the Arab League. Ethiopia also sought support with regional support, the AU, the upstream countries, and so forth. But the Egyptians were much stronger in trying to seek support. Finally, Egypt escalated the matter and submitted a complaint to the UN Security Council, basically alleging that Ethiopia has transgressed international law. It didn't initially notify when the GERD was constructed. There is no obligation, as I said, of notification in this respect, especially when a hydropower project such as the GERD does not entail significant harm. It also said that although Ethiopia proceeded with continuing with the agreement, it later on backed off, and it basically, unless there is a comprehensive agreement, Egypt will be significantly impacted, and there will be millions of deaths and so forth. And therefore, the first stage filling of the GERD should not be undertaken without a comprehensive agreement. That's the condition that they put. Ethiopia responded to that. Ethiopia said that it is within its right to equitably utilize the water resources. There are several benefits and the usual response. But the UN issued a statement for the parties to amicably resolve the pending issues. So the UNSC, at least the Secretary General statement was for the parties themselves to resolve the issues amicably. In the middle of that, on 10 April 2020, Ethiopia proposed to Sudan and Egypt to negotiate on the first stage filling, meaning the current filling and the second one next year, which is 18.5 billion cubic meters, which in any sense does not even have any significant impact. Some people may question why a negotiated agreement on first stage filling. And that is, I think, a legitimate question, because do we need to ask for Egypt and Sudan to accept this? Wouldn't it create a precedent on the future negotiations? And even on future planned projects on the Nile. So this would also be a subject to discussion. Sudan again, Sudan and Ethiopia called Egypt to resume negotiations. Egypt accepted the resumption of the negotiations, but on what conditions, on what terms? If you've seen Egyptian proposals, is that it shouldn't affect Egyptian interest, basically implying historical rights again, and a condition that later on a comprehensive agreement should be conducted. Future scenarios, Ethiopia will proceed to carry out the first stage filling. I think this is highly likely, with or without an agreement. As you may have heard, Sudan has also now lodged a complaint to the UNSC saying that Ethiopia shouldn't proceed with the first stage filling. Basically repeating what the Egyptian position. But I think Ethiopia would proceed to filling the agreement, to filling the dam. I think this is highly likely and should be done. We'll discuss about what impacts that this might entail. I don't think that there will be any war. Egypt and Sudan already know from the outset that this does not have any impact. They want to make this condition for Ethiopia to be forced to enter into an agreement that it doesn't want. That is a condition they want to do. The negotiation of first stage filling will be attached with conditions. Sudan and Egypt are pushing for this. I don't think it might be likely, but if conditions are attached, there will be a significant impact on Ethiopia's interest. We can discuss it. I don't think that Ethiopia should accept the conditions to subsequently proceed with a comprehensive agreement at this stage, including long-term operation. Resumption of talks will lead to the continuation of the Washington process, highly unlikely. I don't think that this would be accepted politically in Ethiopia after what has happened. And I don't think this will be a viable option. Resumption of talks in another platform, that is acceptable, but there will be a lot of controversy of who should be an observer. Egypt would like to have observers that supports it. Ethiopia, of course, but the AU is preferred by Ethiopia, and including the upstream Nile countries, which has a vested interest in these negotiations. Negotiations focus on the filling of dam and not discuss the long-term operation. This is unclear at the moment. The positions are debated to do away with not negotiating on long-term operation. Egypt may revert back to the UNSC, International Court of Justice, if talks fail. This is likely. Ethiopia should be prepared for that. Egypt and Sudan become parties to the Cooperative Framework Agreement. I don't think this would be likely in the short term. Egypt would continue to push and put pressure for Ethiopia to accept a compromise solution. What compromise means should be known. Military option, I don't think this is likely. I don't think this is to the interest of Egypt in any form. But of course, this war of attrition and others are likely. I better stop here because it's better to give time to questions. I think I took a lot of time. I'm sorry to do that. I better stop here. Thank you very much for listening to me, and please proceed to questions now.
Okay, thank you, Imeru. This was extremely informative, and it's worth all of our time. And I really appreciate it. And the questions are coming. Are you ready for those?
I can see some questions here.
Okay, I'm going to pose some of the questions.
You can pose the questions, please.
Okay. Obviously, the first question comes from Negest. She used to be the first one to ask questions at law school. Her question is, what are the tests to determine equitable and reasonable utilization and no significant harm? Any bright line rule type of question is our question, I think. You want to answer that, and then we'll proceed.
Good. Yes, of course. This is one of the big problems in the principles themselves. These are very broad principles, and in the convention there are various factors that have that has been provided as a criteria to determine what is equitable in a given base in a given international basin like the Nile. But these are contentious provisions. It says the water contribution that countries make, the geographical position, the economic needs of countries, geographical, social and economic needs, and so forth. These are very broad criteria. So it's very difficult for countries, especially when there are big contentious issues, to agree on what is equitable in this circumstance. And the other thing is that the no harm principle, the other big issue is the relationship between equitable utilization and the no significant harm, as I've said. there is many say that the governing principle is the principle of equitable utilization. In fact, if you see the provision of no significant harm, it also indicates or directs if there is any significant harm that is entailed on countries, then they should be decided on the basis of Article 6. But this requires that the problem is that these are very broad concepts and are not amenable to easy agreement, especially in the contentious issues that is faced in the Nile. But one thing I should mention is that the significant harm principle, many people think that it's only upstream countries that can cause significant harm. Physically, it might be, but not. But this is reciprocal. Downstream countries which preempt upstream countries from using their water resources is exactly also significant harm. If Ethiopia is not allowed to use its water resources of the Nile to feed its population, to provide electricity to population, it's basically significant harm. So this is reciprocal. People should also not consider the no significant harm as being always in favor of upstream countries. Ethiopia should also underline that harm applies also to Ethiopia. The governing principle under international, the ICJ has decided, if you see there is a case called the Gapchikovo-Nagiramos case that was decided by ICJ in between a dispute between Slovakia and Hungary. And in that, the ICJ has decided that the governing principle is the principle of equitable utilization. But as you said, the criteria are very broad, and therefore it requires countries to agree on the priority criteria that should underline the negotiations. Otherwise, it's always difficult. So that is one of the challenges. I better stop here.
All right, thank you. And the second question is kind of personal. What's your current involvement in the negotiations? And if you're not involved, having such an experience, why are you not involved in it?
That's a very personal question. I mean, that's difficult. No, I'm still on board. So that may not be as actively involved as in the past, but I'm still on board. I still give advice on the issue. I should briefly respond like this. So no, I'm still advising.
Right, great. And the next question is related to Egypt. Why is Egypt dragging the process? And then related to that was recently Egypt also indicated that the Washington talk was mediated by US. Why? What gave them an indication that this was a mediation? The letter that they sent to the UN, they called it mediation, I believe. Somebody.
Yeah, okay. Regarding the mediation, yes, in the UNSC, it says mediation, that the US, in fact, it says that when the US was involved, it was to mediate the process. This is a white lie. I mean, yes, Egypt wanted the US initially to mediate the process, to act as a mediator, but during the November 6 meeting, Ethiopia insisted that mediation is not acceptable, that the World Bank, both the US and the World Bank, should act as observers and not involved in the discussions between the three countries. So mediation wasn't involved. By the way, even in the joint statement, as you have seen, it says observers, not mediators. And in fact, it's only if an agreement is not reached by January 15 that it says the dispute resolution provision of the DOP would be triggered. In that case, mediation can be one of the options. Otherwise, the US's role was never a mediation role. Well, this has been responded to in the Ethiopian response.
All right. Those questions were from Freo Samuel and maybe Udanye. And Daniel also wants to know, what is the legal argument of Egypt, the basic legal arguments of Egypt?
Well, basically, Egypt is saying that the legal argument that Egypt says that it's the historical rights, which don't exist under international water law, which is not recognized, and it should be recognized. That also other upstream countries have agreed during the colonial period to not develop the water resources without the consent of Egypt. That's their argument. I mean, it's a failed argument. Internationally, most of their arguments is unacceptable. But they still insist on that and want to put not a legal pressure, but a political pressure in accepting their demands. By the way, even in their constitution, as you may know, they have a provision saying that Egypt would defend its historic rights. It's in the constitution, and this is a mindset that that has continued for years, and eventually, even if you go to the International Court of Justice, I don't think that Ethiopia would lose. International law supports us, and clearly we shouldn't shy away. I mean, from those, but we should be well prepared if it comes to that.
And let me ask my own question now. In Declaration of Principle, DOP, signed in 2015, Article 5, there was an agreement that the guidelines and rules on the filling of the GERD will be by agreement. Now, would Ethiopia be violating that if they are doing that without the agreement of Sudan and Egypt?
That's a good question. I mean, it says agree on the rules and guidelines. Yes, agree on the rules and guidelines. It doesn't say, it depends upon your interpretation, but it doesn't say agreement. I mean, a full-fledged agreement, meaning a binding kind of, it says agree on rules and guidelines. So it's basically an agreement on the rules and guidelines. That is fine. I mean, you can negotiate on the rules and guidelines on the GERD. The thing is, one, it's on the filling, yes, that's fine. They're talking about long-term operation. It doesn't say long-term operation if you see it says annual operation. Yes, and this would be decided by the owner of the dam. There's also a provision on that. So yes, it has been, it's basically that, but they want an agreement that is more than that. A binding agreement, an international agreement governing one project, the GERD. I don't think that's the objective of this. It doesn't relate to, for instance, a water sharing agreement or an agreement that implies water sharing when you discuss the filling and operation of GERD. So what they want is more than the filling and operation of GERD. They want to be ensured that this filling and especially the operation would never have an impact on their existing use. So it goes beyond the filling and operation of annual operation of GERD. I'm not sure if I've responded to your query exactly.
Okay, let's go to the next question.
Okay.
This is from Israel Governor. How could the downstream riparians harm the interest of upstream because the water has already left the upstream riparian land?
How could the downstream countries harm?
Yes.
Yes. That's the point I was making during my presentation. I mean, you usually think harm as being physical harm, meaning a reduction of the water resources, for instance, yes, on the downstream countries. That is usually the case. But if the use in the downstream countries, like the 1959 agreement, which shares the whole flow of the Nile between Sudan and Egypt, preempts the use of the water resources in upstream countries, it also entails physical harm. Yes. If you don't use your water resources to satisfy your basic needs, people would die. That has happened in the past also. Let me give you an example. During the drought period in the 1980s, millions of people died of famine in Ethiopia. None died in Egypt. Isn't this physical harm? And Egypt was trying to prevent Ethiopia from the past for it not to develop its water resources. This is harm. This is clearly harm, and this has to be seen from this perspective. It is reciprocal. It's not only upstream countries that can cause harm to downstream countries. So I think this perspective should also be raised. It's clearly preventing development in upstream countries is definitely harm.
All right. The next question is about returning to table in DC. Is it being considered? And also related to that, another question, did Ethiopia make any tactical or strategic mistake by attending the DC meeting from the very beginning? These are from Ephraim and Tekle, I think.
Returning to DC, I don't think would, as I've mentioned, is very, very unlikely, unless I don't know. I mean, I don't think it's likely at all. I mean that this issue has become a public issue. The U.S. has clearly come out in favor of Egypt and going to the US again and submit to the wills and whims of the United States and Egypt, I don't think that's possible. And I don't think it's being entertained now. That in all the meetings I've been attending, there's no sign of going back to DC. So it's not an option. The second one was what?
Was it a mistake from the very beginning? Is it diplomacy?
Yeah, there are diverse views on this. In my view, in my personal view, I believe it was a mistake, because even in the past, the US and the World Bank, they have strategic interest in favor of Egypt. And it was very doubtful from the outset that the US would act objectively because of its various interests, and it has proved right. The US has clearly come out on behalf of Egypt, and I don't think it was the right way of accepting the US as a third party. That's a personal view, and we've debated on it during that period also, and I think that is also mentioned by some of the authorities, that there was a discussion on this, and some people objected to that. So, yeah, in my view, it was a mistake.
And Joseph Adami is asking about if there is any model that Ethiopia, Egypt, and Sudan could use from other countries' experience, like the Mekong Water Agreement, India and Pakistan, US-Canada Agreement, and others.
The only, yes, I mean, all these other agreements, you know, one of the basic problem with respect to the specific context of the Nile, I mean, the other countries have different contexts. The water resources were not significantly used, and the balance between the countries the balance of power had been different. In the context of the Nile, such agreements are useful as an umbrella agreement. The Cooperative Framework Agreement was the best option, but clearly Egypt and Sudan, because of their bilateral agreement, said that unless that is respected, then they won't enter into the CFA. Eventually, I think the only solution is for Egypt and Sudan to accept that the equitable right of every upstream country in the Nile. And the lesson is that the CFA is similar to other agreements in the Mekong and in other countries, and even in the Indus and others. And this is the international law. But Egypt wants to continue with imposing its own interest, and the mindset has to change. Eventually, it has to change. Egypt has its own alternative resources. It can use that. It should accommodate Ethiopia's interest. Ethiopia doesn't want at all to have a significant impact, to create a significant impact on Egypt. In fact, studies clearly show that if you build several dams upstream in Ethiopia, we don't have much irrigation water, by the way, to develop irrigation in the Blue Nile. It's a rugged terrain, probably 5 billion cubic meters, which evaporates in the Aswan. The only thing that is a problem with Egypt is the mindset, and this has to change somehow. And Ethiopia and other upstream countries, including the international community, should understand that the only solution in the future should be on the basis of the Cooperative Framework Agreement, which includes the basic international principles of international law. And I think eventually they'll come, but in the short term, I'm not sure that they'll do. They'll always continue with increasing pressure on Ethiopia. And we should also be, usually we are responsive. We don't, sometimes we don't think strategically. And that is one of the things that we need to think about, on how to stem Egyptian pressure on Ethiopia. Yes.
Right. Oh. Go ahead.
No, maybe, is there I think I should stop here.
The next question is related to the diplomatic offensive on the part of Egypt. If your diplomats are going around the Arab countries and also in African countries, and they are engaged in convincing our people. But when we look at Ethiopia, there isn't much done. What is the thinking behind this? And why is Ethiopia not utilizing its diplomatic muscles?
Well, this has been the experience in the past also. Egypt is Egyptian politicians, Egyptian media, which is part of the state. Most of them are state media instruments, are very active. Even the foreign minister, as you've seen, after the impasse had gone to many countries, it has organized the Arab states and so forth. On the part of Ethiopia, I mean, there are diplomatic steps that have been taken, but they're not very visible, as Egypt does. The newspapers there are very active. They support all of the Egyptian positions. In our case, the media is not very supportive of this, and officials also, I mean, do not come out, transparently and inform the public what is happening in the pipeline. I mean, there are various diplomatic initiatives that have been taken with the AU. Many European countries, delegations have been sent to their to the upstream countries also, but you don't hear about this. Egyptians are vocal. Ethiopians are not vocal as Egyptians. Maybe it's also related to capacity in certain instances, and there are, surprisingly, after this event, the post-Washington event, I'm very surprised that I see many people writing articles, many young people, concerned people from the diaspora, doing this. And I think this has to be encouraged. This is the national issue. The public has to be informed. The public has to participate. I'm sure ELPANA would also strengthen its participation in this respect. We should encourage people to write articles on this. You know our culture. We don't write. We don't do that, and this culture has to break down somewhere. And I feel that probably the youngsters should, develop this culture. And it's true. We're very weak diplomatically. We're very weak in the media. It's unfortunate that this is happening, but I think it's improving now more than before, and hopefully that would continue. But we're weak. We still have to have strong forces in this respect. Yes.
Right. Which states in the UN Security Council do you think are likely to back Egypt's request for measures under Chapter 7 in the event Egypt decides to take back this to the UN?
One of it is clear, so I don't have to say it. Well, I mean, in the first place, I think if you look at Chapter 3, one of the main issues is, should the UNSC entertain such kind of, is it a threat to peace and security? So we need to carefully see that. But eventually it's political pressures and members of the UN Security Council that decide on that. And there might be political pressures. I mean, one of it's very clear. I mean, the US is clear. Have you seen the Russian statement, press statement today, issued today or yesterday? Very interesting one. They would not support I mean, from the statement, you can see that Russia is, and I don't think China would also do that. Most of the Security Council members, I think, wouldn't. And the past experience is the same. If you see some of the records of the UNSC on international waters, their basic view is that the countries have to resolve it peacefully. And this is not, in fact, this should not be a cause for insecurity in countries. So I don't think it will be endorsed in any way by the UN Security Council. I mean, the Egyptian, what did Egypt and Sudan lodged. And by the way, Ethiopia is also doing its best to approach members of the Security Council also.
Is there any case law or particular article in international law which is in favor of Ethiopia?
Well, most of the past case laws, yes. I mentioned one case, the 1997 ICJ decision. This was a dispute of one dam called the Gabčíkovo-Nagyramos between Czechoslovakia and Hungary. They had an agreement to build a dam, but later on Hungary withdrew from the agreement, saying that it has serious environmental impacts, and then the Czech the Czech Republic said that it has a right to follow another option, and this was placed as within their agreement that they had already agreed that if dispute arises, it will be submitted to ICJ. So in that decision, the ICJ clearly said that the principle of equitable utilization is the governing principle regarding water use of international rivers. However, the ICJ, as you know, is a subsidiary source of law. Many international experts also say that the equitable utilization is the governing principle, but the agreement, the convention itself clearly shows that the equitable utilization is the governing principle. So in this respect, Ethiopia clearly has not used its water resources. It's the regime is clearly inequitable, and if it comes to that, then I think the decision would be in favor of Ethiopia. But we need very strong lawyers like members of the ELPANA to do that.
All right. Passing that to Sarah. Okay. The next question is, you said in your presentation that Egypt has other resources than Nile. What do you mean by that? I think that question revolves around the question of, isn't Nile the life of Egypt?
Well, one of the things is basically we need to demystify. I mean, Egypt is very good at this. So it always says that Egypt is the Nile, Nile is Egypt, and Egypt is totally dependent. By the way, at this point in time, the contribution of agriculture to the whole Egyptian economy is around 14%. Most of its economic comes from other sectors, tourism and so forth. So Ethiopia, as compared to Ethiopia is most of the water resources of Ethiopia is in the Blue Nile, by the way, 59% of the water resources. Okay, I'll talk about that later, but we're talking about Egypt. Egypt has a huge amount of groundwater resources in what you call the Nubian sandstone aquifer. It's around 40 billion cubic meters or more. Some people say about more than 100 billion. I mean, this is a huge resource. What they say is that using this resource is very expensive, we cannot extract it and so forth. But this is an alternative resource. So they can use it. The other big issue, and Egypt always says that it uses its water resources economically, but most of the crops grown, for instance, in Egypt are not use a lot of water resources, and they're not applied economically, and this doesn't happen. So this is the other, and desalinization is also another option that Egypt should take. These are some of the options that Egypt should take. By the way, no one knows how much water is released from the Aswan Dam. It goes, for instance, as you know, Egypt has the Peace Canal, the El Salam Canal, that is out of the basin. It uses the water resources of the Nile to develop land outside of the basin. It has the Toshka Canal and so forth. So, I mean, the rational use of water resources in Egypt should also be seen as one aspect in negotiations on the Nile.
Thank you. Because we started late, we will take 5 more minutes. And
5?
Yeah, is that okay with you, Imeru?
5 minutes is fine.
Okay. All right.
Yes.
Hold on, is there? I'm looking if there are other questions that I didn't ask. Okay, this is another question from Ephraim. Why can't Ethiopia demand that the 1959 agreement denying even a drop of water to Ethiopia, even if 85% of Nile water reaching Egypt comes from Ethiopia? We seem to start from defensive position all through.
Why can't, okay, denying given a drop of, yes, we seem to start from it. Well, I mean, this is, Ethiopia has always, from the outset, officially put its position that it doesn't recognize the 1959 agreement. Not only Ethiopia, but most of the upstream countries basically have come out in that respect. And that is why the CFA, in no uncertain terms, were accepted by all the upstream Nile Basin countries, saying that they do not recognize the 1959 agreement. Ethiopia always says that it is the country that provides the 85% of the water resources. But in other respects, I mean, what other options do we have? I mean, because of Egyptian position, even within the Nile Basin Initiative, there was this project, similar project, including the border dam, now known as the Grand Ethiopian Renaissance Dam, that was recommended by the Nile Basin Initiative. And Egypt said they won't accept it. In fact, that's what prompted Ethiopia to decide that it has to do something on the ground in order to show that it has the sovereign right to use its water resources. And the only thing that Ethiopia can do in the future also is use its water resources with the resource it has, even though there will be various pressures on that. But unless there is a unilateral option that can be taken by Ethiopia, there will be that would be a war of words. we need to assert our right through developing dams such as the Grand Ethiopian Renaissance Dam in the future in order to counter Egyptian Egyptian demands for us to accept the 1959 agreement. Having said this, I don't think we need to we need to cooperate with Egypt and Sudan. The water resources, they also depend on the water resources. That's why Ethiopia has always been saying that this is a shared water resource. Ethiopia has to satisfy its demand by a certain share, and then Sudan and Egypt should not be denied their justified share. But that is the problem. Egypt does not accept any type of what you call share without its consent, and this is a problem. A mindset has to change, but we should show the international community also that the GERD itself is a source of cooperation and benefit to all the riparian countries, and this is how we should pose, showing cooperation and also showing the benefits of what we are doing upstream, but that also in no uncertain terms not accepting the inequitable legal regime that exists within the Nile Basin to date.
All right. With that, I'll ask Imeru if you have any concluding remark.
I think we this kind of discussion should continue. You should continue with engaging with other experts also here. I can help you on that if you create that kind of opportunity, because many lawyers need to be engaged in this issue. It's a very as Sarah mentioned initially, this is indeed of very big national significance, and we don't have the requisite very well-founded lawyers here. I know some of them are there, very good lawyers who've been participating in this process. Some of them, I think one or two are attending this session, and but the space should also be given for people who are keen to engage in this issue, to the opportunity to engage in this issue. The space within the government is now opening up. There is a public pressure, and the government is opening up somehow. So I think this is an opportunity to further strengthen the engagement of all of you. And I thank you for taking this a lot of time to become participants in the meeting. I'll try to follow up on this issue, and anytime you have questions, if you need information from here, please feel free to get in touch with me, and I'll respond to any of the concerns you have on this issue. And I thank you very much for taking the time to listening to this presentation, and I've enjoyed the discussions. Unfortunately, sometimes the eye contact is not here, so this makes it a bit sad in one instance, but still, I'm glad to have had a lot of participants here, and it shows that there is a big concern on this issue on the part of the Ethiopian community everywhere in the world, which is a very good sign. Thank you very much. I think it's better to stop here.
All right. Thank you, Imeru. I really appreciate and I'm honored to have you here today. And you're the same Imeru that I knew, a decent and smart guy, so going strong. All right, with that, I end my part, and then Sarah, why don't you go ahead and take over?
Thank you, Zacharias. Thank you, Imeru. On behalf of ELPANA board and our participants, I would like to express my deep appreciation for Imeru. You can all see it was an outstanding, top-notch presentation he made. It's evident for all of us that he is well versed on the topic. And a very great asset for our country. So thank you again, Imeru. We've all been educated and informed today and engaged. Thank you, Zacharias, as well. Thank you for moderating the Q&A section. Your role was critical in making this program continue seamlessly. Thank you very much. It's very appreciated. Thank you for our participants as well. Thank you for being engaged with us today. I'm sure all of you have been informed, engaged, and as Imeru suggested, this will to some extent propel you into the dialogue, the conversation, the writings, and so forth. We hope would be an outcome to this. We're open to any discussions or any other topics you have in the future. Your opinion matters to us. Tell us what you think, how you benefited today. If there is anything we need to improve, you can go to www.elpana.org and take the survey questions that will help us to be organized and prepare on topics and other matters that might be of critical importance for our legal professionals in the diaspora. With that, thank you. I appreciate your time this morning in here in Minnesota, not necessarily for everyone. I think for Imeru, it's late in the night. And with that, I say thank you and have a great the rest of the day or evening. Bye.
Thank you very much. Bye-bye. Bye.